English, little bit of Hindi mix, more of an English.
When we started the series in respect of celebrating 75 years of Constitution of India, we felt that there would be a challenge in respect of that. But as the journey started off, we found that a lot of speakers were willing to share their knowledge in respect of Constitution and beyond that, just akin to the name of Beyond Law CLC.
Okay.
This aspect is in respect of constitutionality on principles of mutuality and the GST. GST, you would have seen that it's a niche area and a lot of where people having a great specialization log into it and understand the nuances. We thought that the best way to understand this aspect would be from Advocate CA Harsh Gadodia. And we are happy that he has joined with us, and we are also thankful to Mamta Binani for sharing a resourceful person. At the moment, day before yesterday, we connected with him. He happily shared. That perspective shows that he's so confident in respect of sharing his knowledge. Thank you, Mr. Harsh. And over to you.
Thank you so much. It's audible? Thank you, Beyond Law, first of all, for giving this opportunity to share my little knowledge about the subject matter. And moreover, all the participants who are there right now, especially in the Sunday evening that has joined for this seminar. So I'm not going to take much time on this, and we'll straight away start with the principle of mutuality. So what is principle of mutuality, first of all? So it says that one cannot earn profit from himself. That means one man cannot trade with himself in order to make a profit from it. So this concept of principle of mutuality has basically been borrowed from the English decisions and has been adopted over the long period of time in the Indian tax jurisprudence, mainly it's applicable in the income tax or indirect taxation part of it. So how it started? So there is a entry number 2, list 2, entry 54, which says that tax on sale and purchase of goods. Now the sale has not been defined. So the sale has been borrowed. The concept of sale has been borrowed from the Sales of Goods Act, which says that there should be a 2% in order to make a taxable transaction or in order to make a taxable event. So there must be necessity of 2% that is required. Now what happened in this particular principle of mutuality, although it's a very old doctrine, but it has been tested before the code of law. Not now, but it has been, the litigation in this particular subject matter has been started from 1900 and 1940 onwards till date today also. The principle of mutuality are being still tested before the High Court or before the Supreme Court. There is two reasons why it has traveled so long and why it is always tested before the court of law. So it is a settled legal connotation which says that in order to make a taxable event between there should be a 2% that is required. However, to overcome this barrier, so sometimes the constitution itself has been amended in order to incorporate certain entries which are beyond the purview of the sale. So we basically call them deemed sale. Or sometimes the legislation has been given the power to amend the statute. So they basically amend the statute itself by redefining the word sale, supply, services in order to make a deeming fiction, creating that these are the two legal separate entity. So today our discussion would be more towards the principle in case of incorporated association, unincorporated association, in case of what will be the taxable event when the clubs are providing services to the members, or whether transaction will be leveled through tax when the services are being provided by the research society to its members. So how it all started? So in 1968, the three members bench of the Honorable Supreme Court held that the term sale in entry 54 list 2 has to be interpreted in the broad concept to include the transaction of supply of goods or services by clubs to his members. Now, what they say that the incorporated association is basically the incorporated association means if it is registered under the Companies Act or if it is registered under the Society Registration Society Act, so it will consider as a corporate entity, separate corporate. So Honorable Supreme Court says that in case of incorporated association, incorporated entity, the incorporated entity and the members are two distinct legal person. So if these are two distinct legal person, whatever there is a supply from one person from by club to the members, it will be considered as a sale of transaction between two different person, and it would be leviable to the sales tax. That means it will in case of incorporated entity, there is no principle of mutuality that prevails. However, at the same time, in 1968 three members bench, this particular judgment has hold that in case of unincorporated clubs or unincorporated associations, no such two distinct legal entities exist. That means there is no transfer of property from one person to another because two persons and doesn't exist. It's a single person, so it will not liable to service tax. At the same time, the bench has held that if the incorporated clubs or incorporated associations proves that it act as an agent on behalf of the member to facilitate the sale, that in that case it will not be considered as a two distinct legal person, it will consider a single person, that is principle of mutuality will prevail. So this particular three-member Supreme Court judgment came in 1968, which has been further challenged before the honorable six-member Supreme Court bench. In case of joint commercial tax officers versus Young Men Indian Association. Now, what they have mentioned, what they have held in Young Men Indian Association is a six-member Supreme Court judgment. It says that when a club, even if a separate legal entity, act purely as an agent for his member in supplying goods, no sale occurs due to absence of property transfer. So, six-member bench has distinguished the judgment of the three members bench and specifically mentioned that even it is an incorporated entity and it act as an agent to the members, so it will not be considered as it will not be considered as sale because there is absence of two distinct legal entity. Further, they stress that the tax liability depends on the legal nature of the transaction. So, for if the club supply his own goods to the member, it will be considered a sale. In that case, the club and the members are two distinct legal entities. The principle of mutuality will not prevail. However, if the club proves that if act as an agent on behalf of the members, then in that case, it will be considered a single entity and the principle of mutuality would be prevailed. So six members bench, this Young Men's Indian Association, six-member bench Supreme Court judgment in 1970 was a landmark judgment which clearly upheld the principle of mutuality. Now, in order to over this concept of principle of mutuality, overcome this particular judgment, so what they have done, they have made an amendment in the Constitution, White 46 Constitution Amendment Act 1982. So what they have basically done, they have introduced the definition of the term tax on sale or purchase of goods. This particularly entry has been introduced by Article 366(29)(a). This 366(29)(a) basically covers six instances where which are normally don't fall under the purview of sale. Reason behind that is two distinct legal entities doesn't exist. However, by deeming fiction, this particular six instances has been amended. It is to be noted that this amendment has been done in the Constitution, not in the statute. And this amendment has been done via introduction of the Article 366(29)(a). Now, one of the article of 366(29)(a), Clause E, what it says? It says that a tax on the supply of goods by any unincorporated association or body or person to a member thereof for cash, deferred payment, or other valuable considerations. So, what they have mentioned that if there is a supply of goods by the unincorporated member, association, or body or person to the member thereof for cash deferred payment, it will be considered as two distinct legal entity, and the principle of mutuality will not prevail, and it will be leviable to the sales tax. Now, it is to be noted here that when this particular clause has been introduced via Article 366/29A, they have only covered unincorporated association. They have not covered incorporated association. Why? They have misinterpreted the earlier Supreme Court judgment of Young Men's Indian Association, which says that whenever if the unincorporated association, it's a clear judgment which says that it will not be considered as a two legal entity because it doesn't exist. However, in case of incorporated, they mentioned that if it acts as an agent on behalf of the member, then it will consider as a principle. In that case, the principle of mutuality will prevail. Otherwise, it not. However, when 366/29A they has misinterpreted this particular judgment and thought that the idea to include supply by unincorporated association was that sale by a registered club to his member is taxable since both are different legal entities. Hence, the amendment did not include supply by incorporated association. Clause of unincorporation association in Article association will always be considered as separate legal entities of the two members, two distinct entities. Incorporated association to its members will be considered. So they are only incorporated or unincorporated association. Now, this principle of mutuality has been tested before the court of law in various times. In case of Rachi or club, or in case of Gujarat, in case of Sports Club Limited. However, the landmark judgment came in 2019 in case of Calcutta clubs. So what happened basically in service tax prior to 2012, there was no levy of service tax on it. However, post 2012, they have amended the statute itself to create a deeming fiction that unincorporated association and a member will be considered two distinct legal entity. So it's always a matter of litigation before the court of law whether the principle of mutuality will prevail and says that no service tax will be levied. So this particular matter has been reached to the Honorable Supreme Court in case of Calcutta Club Limited. The question of law that has been framed before the Calcutta Club Limited, before the Honorable Supreme Court in case of Calcutta Club Limited is number one, whether the doctrine of mutuality is still applicable to incorporated clubs or any clubs after 46th Amendment to Article 366/29A of the Constitution of India. Number two, whether the judgment of this court in Young Men Indian Association still holds the field after the 46th Amendment. And so the first thing we got to know that in case of Supreme Young Man Indian Association, they have uphold the concept of principle of mutuality and says that in case of a club there is no two distinct legal entities, so the principle of mutuality will prevail and there will be no service tax or no sales tax on it. To overcome this particular Supreme Court judgment, they have amended the Constitution by Article 366/29A, where they have incorporated a particular clause E, where they say that the sale by unincorporated association to its member for cash deferred payment will be considered as a two separate legal distinct entities. After this, when the matter has reached to the Calcutta High Court, the question that has been framed before the Calcutta High Court is whether the judgment of the Young Men Association still upholds after the 46th Amendment. Number two, whether the doctrine of mutuality is still applicable to incorporated clubs or any clubs after the 46th Amendment to Article 360/29A of the Constitution of India. Now, in this particular judgment of Calcutta Club Limited, the larger bench of the Honorable Supreme Court held that the supply, sale, and sale of good or rendering of services by incorporated or unincorporated association or clubs to their members are not liable to sales tax by application of principle of mutuality even after 46th Amendment to the Constitution. So they have clearly mentioned that even after 46th Amendment that had happened in the Constitution by Article 369A, the principle of mutuality still prevails. So if in case any services or sale of goods happen between the incorporated club or incorporated association to its members, or unincorporated club or association to its members, it will still principle of mutuality will prevail, and there will be no levy of sales tax or service tax. Now the question rises, on what grounds this particular judgment has been upheld. The first ground that has been mentioned, that is the 61st Law Commission report, which recommended the 46th constitutional amendment, was of the view that the constitution ought not to be amended so as to bring within tax net members club for the following reasons. Number one, the number of such clubs and associations would not be very large. Number two, the taxation of such transaction might discourage the cooperative movement. And number three, the no serious question of evasion of tax arises as a member of such clubs really takes his own goods. So the 61st Law Commission report itself mentioned that there will be no tax on the transaction between the clubs and his members. The second point that has been raised by the Calcutta Club is they have mentioned that the statement of object and the reason that for the 46 amendments did not properly understand the decision of the Supreme Court in case of a Young Men's Indian Association and assumed that the sale of goods by member clubs in the corporate form were taxable. However, they have missed the main concept that the decision of the Young Men Indian Association has placed reliance on two English decisions, that is Graf versus Even and the Tribong Working Men's Club versus McDonald, which pertain to incorporated clubs, and hence the concept of mutuality would be applicable to the incorporated club or association also. And the third and the most important point that has been mentioned by the Supreme Court held that even in case of sale and supply of goods by unincorporated association or body of person to members, the requirement of condition is not fulfilled since it is a case of sale of good to self. There is no consideration as per the provision of Contract Act 1872. That is, the Honorable Supreme Court in case of Calcutta Club Limited also held that whether it's an incorporated association or unincorporated association, any service or any sale by the clubs to his members or by the research society to his members would fall under the purview of principle of mutuality, and principle of mutuality will prevail, and there will be no levy of sales tax or service tax on it. Now, this decision was in the financial year 2019. Laws with respect to the goods and service tax imposed by Parliament. The state has the power to make the laws with respect to the good and service tax. Now, what is good and service tax? This good and service tax has been defined under Article 366 12A. If we go to Article 366 12A, three sixty six twelve A says that good and service tax means any tax on supply of goods or services or both, except tax on the supply of alcoholic liquor for human consumptions. Now, the Parliament and the state have the power to amend the laws related to the good and service tax. That is very clear from the Constitution of Article 2 of from the Article 246A, and the definition of good and service tax is also very clear from Article 366 12A. Now, what happened basically, when the in 2019, when the Calcutta Club Limited judgment came, which upholds the principle of mutuality, to overcome this particular judgment, in 2021, they have amended the definition of supply itself and the definition of the person under the Good and Service Tax Act. in the section 7A, they have amended the definition of good and service. They have amended definition to include that unincorporated association and its member would be considered two legal distinct entity, and any taxable event between the two will be any event between the two will be considered as a supply. And at the same time, they have amended definition of the person. This amendment has been made in 2021. However, to overcome this particular judgment of Calcutta Club Limited, they have retrospectively amended the said Act from 1/7/2017, that is from the beginning when the GST has been introduced. So if we see the entire series of if we go to the history of the principle of mutuality, what we basically see that there are a lot of Supreme Court judgments which have held that it will not be leviable to sales tax. So whenever there is a particular Supreme Court judgment come, they basically either amend the constitution, by Article 360-29A is one of the example, or where they get the power to amend the statute, they basically amend the definition of the sale, or they amend the definition of the services, or they amend the definition of the supply in the statute itself to overcome the settled principle of mutuality. In one of the matter in 1948, I think 1950, in case of Gannon Duckley. Yes, in case of State of Madras versus Ghana Duckley and Company Madras Limited, the constitutional power was to levy only a tax on sale or purchase of goods. The state legislature sought to expand this power by inserting an artificial definition in the sales tax legislation to the effect that sales would include works contract. Now, this was struck down in Ghana Duckley a bit on the ground that accepting meaning of a term in a constitutional phrase could not be statutorily expanded. So what happened basically in this particular judgment is that uh, the definition of the sale has been expanded by the state legislature by including the word of works contract in the sale. So they amended the statute and expanded the definition of sale in order to include the works contract to be fall under the purview of this particular sales definition. It has been struck down by this particular Supreme Court in case of Ghana Duckley and X by stating that the accepted meaning of the term in constitutional phrase cannot be statutorily expanded. So what they basically means that if any particular legal connotation which has already been accepted over the period of time by various judicial pronouncement, it cannot be it cannot be taken over only by amending the statute. So a constitutional amendment would be required in order to overcome this particular thing. Now what happened basically in good and service tax, it has been pronounced by various high court and even by various Supreme Court. But to overcome this particular judgment of Calcutta Club Limited, they have amended the good and service tax itself in section 7 and in section 2 to consider by creating a deeming fiction that unincorporated associations and its members are two distinct legal persons. So now this particular matter again flowed in the good and service tax. Now in one of the cases, in case of Indian Medical Association, this matter has been reached into the Kerala High Court. In 2024, when the matter has reached to a single member bench of the Kerala High Court, the question rises before the bench is whether, when a particular legal connotation, that is principle of mutuality, has been already settled, can we take away this settled principle by amending the statute, or we have to do amendment in the uh, constitution? In 2004, however, the single member bench has held that the Parliament and state legislatures amended Section 7A by inserting Section 7 subclause A by the Finance Act 2021. The amendment as held is neither beyond legislative competence nor offers any of the fundamental rights guarantee under Part 3 of the Constitution of India, nor is manifestly arbitrary or capricious. Therefore, the amendment brought in Section 7A by inserting Section 7 is well within the legislative competence and is not ultra vires. The single member bench has already has upheld that the whatever the amendment has been carried out in the statute in order to make a two distinct legal entity of unincorporated association and its members, it has not been declared ultra vires whether it has been said as well within the power of the parliament and state legislature. Now, this particular judgment has again been challenged before the division bench in Kerala High Court in 2025. And in 2025, the question again arises before the court of law whether by amending the statute can we overcome the well settled judicial principles that has been settled over the period of time, this principle of mutuality, or in order to make the in order to overcome this principle we have to make the amendment in the constitution of law only. So this particular Kerala High Court judgment in para 23 has specifically held that we are also conscious of the decision in case of Rakhi Kohli and the that postulate that legislature has to be accorded a great degree of latitude in laws related to economic activities and that no statute should be struck down unless it is vitiated by the constitutional infirmity. We do, however, find that statute provisions implied in this proceeding suffer from a definitive lack of legislative competence. Accordingly, the provision of Section 2, subsection 17, clause E, and Section 7, subsection 1, clause AA, and the explanation thereto of the CGST Act 2017, and the provision of Section 217E and 71AA, and the explanation thereto are declared unconstitutional and void, being ultra vires the provision of 246A, read with Article 366(12)A and Article 265 of the Constitution of India. So in this particular judgment, Calcutta High Court, they have specifically held that the amendment that has been carried out in the statute in order to make unincorporated association and its members as two distinct legal entities is ultra vires to the provision of Article 246A, read with Article 366(12)A and Article 265 of the Constitution of India. To this particular Kerala High Court judgment of divisional bench, it is quite clear that the principle of mutuality prevails. In order to overcome the principle of mutuality, you cannot do by amending the particular statute. The only thing is possible that is you have to amend the constitution in order to overcome this principle of mutuality. That has been mentioned by various High Court and Supreme Court. I hope it is clear as of now. Is any doubt about this?
It's fine. It's fine. Ash, it's fine. Hello. Is it audible?
Hello?
I said it's fine.
Yeah.
Yeah. So what can be done is, hello.
Yes, I'm audible now.
Hello.
Hello.
Yeah, I'm saying if you could just summarize the gist what you have spoken till now, people will be able to understand better.
So I just want to say in a single, from beginning to end in a single thing. Principle of mutuality has been borrowed from the English decisions that two distinct legal entities has to be there in order to make a taxable event, in order to levy a tax or sales tax or service tax. Now, this particular young man in association, there is Supreme Court judgment, has upheld the principle of mutuality by stating that unincorporated association or incorporated association, if they are supplying any good or services to its members, since members and associations are a single distinct entity, there is no separate entity. So in the absence of two distinct legal entities, there cannot be a sale transaction of one person to another because the principle of mutuality will prevail and there will be no tax on it. To overcome this particular judgment of young men associations, they have made the amendment in the Constitution via 46 Constitution Amendment Act in 1986, while introducing Article 366(29)A, where they have where have introduced six instances in Article 366(29)(a), that these are the six instances which doesn't fall under the purview of the sales. However, to overcome this Supreme Court judgment, they have introduced as a deemed sale concept. One of the clause is an unincorporated association, and the members will be considered two distinct legal entity for the purpose of the sale under Article 360(29)(a). Now, when the matter has traveled to the Calcutta Club Limited the Honorable Supreme Court in 2019 has held that even after the constitutional amendment, 46 constitutional amendment, the unincorporated association and the body of person would be considered as a single person. That is, the principle of mutuality will prevail. Even by that constitutional amendment, it's not going to deny that particular benefit. In 2017, when the good and service tax has been introduced, where the Article 246A has given, wherein the state and the parliament has been given power to enact the law in relation to Good and Service Tax Act, they have amended the definition of supply in Section 7(1)(aa) and Section 2 to make a deeming fiction that unincorporated association and members are two distinct legal entities. So, on the basis of this particular amendment, the department started issuing the notices to the various clubs and association registered society that whatever the transaction that has taken place between the registered society or clubs with the members, that is whether sale or supply of services, all this transaction will fall under the purview of the GST, and the GST has to be paid on it. The matter has travelled to the Kerala High Court. The single member bench of the Kerala High Court has held that the amendment that has been, and it's not ultra-wise to the constitution, so the tax will be levied on it. However, they mentioned that the tax will not be levied retrospectively, it will be levied prospectively from 2021 when the amendment has been happened. Now, again, this single member bench of Kerala High Court has been challenged in the divisional bench of the Kerala High Court, and divisional bench of the Kerala High Court again upheld the principle of mutuality, that the principle of mutuality is a legal condition which has been very well settled over the period of time by various Supreme Court judgments. So, if any amendment has to be made in order to bifurcate the unincorporated association member two distinct legal person, it cannot be done via statute. It has to be done via constitution that has been done previously in 46 amendment. It has to be done via constitution, not via statute. So the amendment that has been made in the definition of the supply in order to segregate unincorporated association and members to the Article 246A and 300 306(12)(a) and Article 265 of the Constitution of India, and says that principle of mutuality will always prevail. So after this particular judgment, we are aware of there are lot of transactions that are taking place between an incorporated association and corporate association with its members. Whether you take the any society that has been registered as registered as a Society Act, or whether it's any club that is registered as a under the Companies Act also. So if any services, any supply has taken place with this member, it will be considered as it's a single person, and no transaction will be leviable to GST on it. So so this principle of mutuality plays a very vital role in order to safeguard these particular transactions. I hope it is now very clear with regard to what is the principle of mutuality.
Yeah. So, what is your take? Like you said, it has to be applied. It cannot be applied retrospectively. Like no, in the normal course, the law is that the high courts can't do, but under Article 142, they can say that it cannot apply retrospectively. So, what is for that?
I think we have already a lot of judgment with regard to the retrospective effect, and lot of I think the detail has great discussion has been also been made in case of Indian Medical Association judgment, which we have discussed over Kerala High Court, that retrospective amendment always destroyed the industry confidence upon the entire thing, and the court and in various cases has already uphold that retrospective amendment should not be brought. Although there is one particular judgment of, I think, royalty on minerals and taxations, if you are aware of this particular judgment, where they have upheld the tax on the royalty with retrospectively.
Thank you, Mr. Harsh, for sharing the insights. I'll just check as to whether we have any questions on the YouTube. No. Thank you.
Thank you so much.